welcome to Bharata First. You're watching The Discourse. I'm Rausan Pereira. And today we're going to talk about an interesting topic, the IBC Amendment Bill, of course. Very important because the IBC has been in existence since 2016. There has been a lot of clamor for some kind of changes to be brought in to make it smoother, to ensure that the process itself is far clearer and far more smoother going into the future. I have a special list of guests here with me on the program today to talk about what kind of changes we would like to see in the IBC and what kind of an IBC is desired. I have with me on the program Mr. M.S. Sahu or Dr. Sahu, who is the former chairman of the IBBI, which is the Insolvency and Bankruptcy Board of India. Also with me is Sumant Batra, insolvency lawyer, a renowned lawyer, of course, in this particular area, and he's here with us as well. Also, Deepika B. Prasad, an insolvency expert. Thank you so much for being here. And finally, last but not the least, Manindra K. Tiwari, insolvency professional as well. Thank you, all of you, for being here on this special podcast. Dr. Sahu, I'd like to start with you first. How would you look at this amendment bill? What is it that really stands out for you? What are the key aspects?
Thank you so much for having me here. I think, as you know, this insolvency law has been one of the fundamental economic reforms. Government brought it in 2016 with a lot of hope, a lot of expectation, passion, and nurtured it very carefully. But when government was finding that things are not moving the way it expected, there have been some deviations here and there. So government wanted to set it right. It didn't want the IBC to slip off the track. So what it has done essentially is, it has tried to remove all the irritations that has come up over last 3, 4, 5 years. Because government thinks, and there's a thinking, there's a feeling everywhere that if there's a problem, it is the legislature must fix it. So parliament could not have remained quiet. So what it has done, I would put it in 3 sets of major changes it has done. One is, big change is that it is directed against government agencies, executive and judiciary. The way these agencies have been handling IBC, Parliament's expectation is much, much higher. For example, now government says that the adjudicating authority must dispose of the matters within X days. And if it does not do, it has to give a reason for that. It says also government shall submit claims within the timeline. If it does not submit, the claim will be extinguished. The resolution applicant will take over the company on a clean slate. These things were understood long back. These were part of the law. But somewhere on the way, various agencies interpreted differently. For example, another example is that the law says insolvency process can be triggered when there is a default. That has been the consistent understanding starting from the innovative, very fast case in 2017. That is what Parliament told through notes on clauses, through Bankruptcy Law Reforms Committee, through several ways. And that is what got settled. But sometime in 2022, Honorable Supreme Court told that that's not good enough. The company must be bankrupt. So that changed the entire thinking. So government had to rectify that. Now what government has done is, it says that this NCLT shall admit an application when there is a default. It shall not consider any other factor while deciding the admission. So it's a double cushion. You will consider this and you will not consider something else. But that does not mean that this is a full insurance that the authorities will not interpret it differently.
Right.
But fortunately, this time the notes and clauses are a little more detailed. I hope the divergent opinions should not arise as much. The second set of things are very big things actually there, which have not been detailed, related to the cross-border insolvency and group insolvency, which can give a lot more value to our transactions. But we have to wait for the details to come through the subordinate legislation.
Right. Absolutely. Thank you for so beautifully pointing out these aspects and what the key changes are going to look like really as far as the amendments are concerned. So, Batra, I'd like to bring you into the picture now. Mr. Sahu was talking about the details and how the amendments or the amendment bill is far more detailed. But sometimes the devil is in the details as well. So it really remains to be seen what happens and how it is implemented as well, because implementation too is going to be key.
Yeah, first of all, thank you, Frank, for having me on the show. It's always a pleasure to talk to you. I just would like to supplement Dr. Sao a little bit, and then I'll answer your question. I see the provisions of the bill in four categories. One is the second generation of reforms, which were actually long due. They should have come about 4 or 5 years ago. And these are three. One, cross-border insolvency. Two, group insolvency. And third is the pre-insolvency resolution, which is manifested in the form of creditor-initiated insolvency resolution process, which has become almost like a norm in many advanced jurisdictions, and we've been propagating it for quite some time. So these three are next generation reforms, long overdue, which have now found place in the bill. The second is, as Dr. Sao was mentioning as his first point, that it addresses the causes for delays in the NCLT, as well as some of the procedural aspects, and two, more significantly, the implementation issues. The third category is the filling up of the gaps and making some corrections. Like, for example, liquidation. I mean, Dr. Sao and I have discussed this for many, many years, that liquidation is always a choice that the lenders should retain. It's not really right to say, oh, you should keep kicking the can down the lane, keep trying for resolution till you get tired, only then liquidate the company. I mean, that's a choice that is best left to the lenders. This is one instance where I might say gaps filled, corrections made. And the fourth, I believe, is it is a reinforcement of the political will that the market wanted to see behind IBC, which for 2-3 years was beginning to sort of fade away. And I see that as a very significant thing because it paves the way for future reforms also. So there are very strong messages in that. Example, what Dr. Sao mentioned, that we will even go to the extent of making certain provisions as substantive provisions in law, even though they need to be understood as basic things. For example, everything gets extinguished. Why do you need to say in the law? But the politicians, the parliament said, no, we will go to that extent because we want to give a very powerful message that the intent of the law needs to be implemented, even if some of the institutions are not following it or the government departments are not following it. That's a very strong message. So I think there is a fourth category that I'd like to sort of place into it. So these are four. Now to answer your question very quickly. Now, as far as the cross-border insolvency framework is concerned, and the group insolvency, it will come in the form of rules and regulations.
Right.
But Dr. Sao was in IBBI when most of these were already framed. And they've gone through a big drill, including a public consultation. Some of it may need to be fine-tuned. I can't share all the details here, but they have been to a large extent already. They are ripe. And I'm sure in a very short span of time, after the Parliament approves the bill, these will come out for public consultation. And they would also be, I'm very confident, of global standards. When it comes to implementation, it lot depends on the market. However clear your rules, regulations, laws might be, it all depends on the market players, how they ultimately deal with it in terms of their response. So that's how I say it. I'm very optimistic that it sort of will work out very well.
Absolutely. Yeah, well, we are all optimistic. We hope that it will work out well. And it's time that we see a far more streamlined IBC, because it's a very, very important piece of legislation and law that really needs to be strengthened. Deepika Prasad, let me bring you into the picture now. Let's also talk about, both panelists have spoken about irritants and gaps. What are some of these biggest irritants and gaps, and how can they really be filled?
So thank you very much, first of all, for having me on this show. Well, yes, I would like to take it from here that what are the major irritants or the gaps in the law. I would like to start with the very important issue of the credit market in our country. While we are right now looking at India at 2047, there are many gaps as it is that we need to fulfill, where our economy is just reaching such robust spaces. So the security market in our country, wherein, there were certain gaps related to the IBC, wherein the statutory securities as given in the other laws were now becoming at par with the securities, the financial securities created in law as per IBC. Now, which is one big gap which this amendment bill, proposes to fulfill, rather to fill the gap. After this gap is really filled, the security created by the lenders and the financial institutions will definitely have a kind of a priority, and the gap which was filled by the rainbow papers will be filled. So this is one area which required much thinking, and our jurisprudence was emerging for it, but this particular amendment bill is really going to cover it well. That is number one. Two, I feel that the way we are expecting our economy and our country to really be at par with the international standards, and the ease of doing business is something that we are really looking after, so the area which talks of the exit route in our country for these businesses is something which is definitely being looked at by the IBC as such, but there were certain areas which were not getting their closure, like the dissolution of the companies. In spite of the regulations supporting liquidation and supporting the CIRP in a way so that the companies may live, the closure process was still not as streamlined as it should have been. So rather, I would say that this particular bill, the Amendment Bill 2025, really proposes to make that closure process even more streamlined. As the dissolution will have now, it'll be more streamlined in a way that the companies will be able to overtake committee of creditors, which is one part of that is the COC, which is one part of the most important framework of the IBC, will be able to take over the litigations, and the companies will be able to be dissolved easily. Absolutely. So I feel this is one more area which is getting covered.
Absolutely. And since we are here, Manindra, let me also discuss and talk about the other aspect, taking this particular point forward of an irritant and a gap that people have been talking now for, 9 years, is the fact that the entire resolution process, the timeline and the time frame itself is too long. And do you see that being addressed? How do we address that challenge?
Thanks for calling me here. And the gap, basically IBC is a revolutionary act which has been passed in 2016. And the basic preamble, if you see, that will be the fast resolution and efficient resolutions with easy exit, with maximization of the assets. In between the 9 years, what we have covered through all those jurisprudence and other things. So there are some, we feel that in admission of the applications, claims, or addressing the buffet transactions, or addressing the liquidation processes, and everywhere due to some jurisprudence or interpretations, or you can see in a larger horizon, that somewhere we have lost our timelines. And the basic thing for which this IBC law was created, that has not been fulfilled. Right now, through this amendment, the government and legislature tried to fix few issues. The few issues are like in admission of claim, like since 2017-18, what we have seen that they have gone beyond deficiency and default. And therefore that admission time will be from 2 months to 6 months or a year. So that has been timelined, and that has been fixed by this amendment through giving the reason that you have to see only as a financial act, you have to see only as a default and deficiency, nothing else will be seen. And that will be passed within 14 days. Application should be admitted or rejected. Otherwise, you have to write your reasons for not being in complied or whatever reasons are there. So this one gap has been certainly aspected in that way. Second aspect of these during the CIRP processes, what we have seen that these buffet transactions, if something happens, the liquidation process or CIRP or resolution applications approvals, they take more time. because of these perfect transactions. So legislature again filled this gap, and they have disintegrated both the things, that CIRP or liquidation as well as these perfect transactions cases hearings that will be go separately.
Absolutely.
Third thing they have addressed where the time has been taken, that is the liquidation. Even liquidation they have amended the way that COC will replace the liquidator if they want. COC will have the power to monitor the process, and that must be within a year or so. So that will be addressed. So I think this time of things, this IBC 2.0, that has sufficiently covered all those loopholes, and they have tried to reduce the timeline and be on the same first 2016, the preamble of the IBC, that it should be fast and forward, and this should be the asset maximizations also.
Absolutely, absolutely. Dr. Sahu, let me come back to you now. Let's also try and understand, the importance of the IBC first and foremost, put into perspective for us and for our viewers. Most of our viewers are in the age category of 18 to 35. About 80% of our viewers are in that category. So they would like to know, of course, what has been achieved through the IBC so far, because you've been so instrumental, really the man as far as the IBC is concerned. So we'd like to hear from you, what is it that we've achieved through the IBC, and are you happy with what you've seen over the last 9 years?
Yeah, I am more than happy on what has happened, but it could have been a little better. What has happened is, the Insolvency and Bankruptcy Code provides for resolution of stress of companies and other persons also. Law has been implemented only in respect of corporates. We are yet to start the individual insolvency, proprietorship and partnership. That is in fact a bigger bucket. We have not opened it up. That is where one area we are lacking. As regards corporate insolvency, we have moved number-wise, okay, let me give you very briefly the numbers. About 8,000 companies have admitted into the process. Of them, only 2,000 or so are yet to exit. The rest have exited in different forms. About 1,500 of them have ended up with the resolution plans. About 3,000 have proceeded to liquidation. So generally, the focus on discussion is about these 1,500 companies which have been reserved. And through that resolution, banks have been able to get about 3.5 lakh crores ready cash. And that amounts to about 170% of the liquidation value. That means if these companies were liquidated, the lenders would have got at best 100 rupees, but this process has given them 170 rupees. Even there are instances where the resolution plans are giving higher than the fair value. That's why we find today in the credit market system, the NPA is historically low today, 2.5%. When we started, say, 2018, mid-2018, it has reached a peak of 13%. And that year, 2017-18, the aggregate loss of the banking system was about 60,000-70,000 crore. Today, we have 3.2 lakh crore of profits. So this is how that has changed the banking sector. Equally, changes have happened in the corporate sector. IIM data says that after resolution of these companies, over 3 years, when they were tracked at 3 years' time, the market capitalization, asset utilization, employment in all parameters, including the stock price movement, they are at par with the comparable companies. So that means post-resolution, they have really got back to on their feet. So that way things have improved, have happened. But where we are lagging behind is essentially the timeline. The last newsletter of IBBI says that the corporate insolvency resolution process takes about 900 days, nearly 900 days for completion, as against 330 days provided in the statute. That is where we are actually falling short in a big margin. But I am not too sure also the prescriptions that have come in this bill will address that fully. We know there were earlier provisions that the 330 days will be mandatory, but courts believe that no, nothing can be mandatory for courts, it will be directory. Even though there is a timeline limit on the NCLT to do in 14 days, 30 days, this and that, but there is no consequences for not doing so. So until you bring that obligation, that liability, if you do not deliver, and of course, you have to also empower them to deliver. If they don't have the capacity to deliver, you can't expect that. So you need to provide for consequences for non-delivery, as well as there has to be commensurate improvement in the capacity to address the capacity. But more importantly, this is giving another message that which Mr. Batra is talking about. A new format has come up, creditor-led insolvency resolution process. That's saying that because they have not telling in so many words, but saying that because this institution NCLT, there is a difficulty in getting service from that, we will now move away from there and find out our own ways. So this may happen in a larger manner in the days to come if these institutions do not deliver. In fact, I believe that there are timelines for market participants. You have to deliver in X days, Y days. And today the law is saying that NCLT will have timeline, but no timeline for appellate authority and Supreme Court. The Bhushan case, which has been in the news very recently, Supreme Court took 5 years to dispose of. So the transaction which was concluded, implemented, reversed after 5 years. So why can't we have the law that why should government authorities approve in 3 layers? And every higher layer can say that the junior layer was wrong and I undo it. But the consequences of this is on the market, not on those government authorities. If market people take decision at one go, let the government authority take a decision at one go. Let there be only one approval at NCLT within timeline. You find there are several problems that approval has gone through. There are illegalities. NCLT should not have approved. Address those, interpret the law, let appeal go to Supreme Court for interpretation of law. Find out all those irregularities, hang them whatever best way you can, but don't touch the transaction. So be at market level. If market has one chance, one time limit, the approving authority must also have only one chance, one time limit, because this is an orchestra. Otherwise, the game can't go on.
Absolutely. Very important and very interesting points raised there by Dr. Sahu. I'd like to take them forward with you, Sumant Batra. You know, since you deal with these matters so closely, you look at them on a daily basis so closely as well, what's the way out? Because that's the biggest issue, isn't it? Because like pointed out earlier by Manindra as well, you know, and Dr. Sahu, 330 to 900 days, that's a huge lapse and a huge gap. What's the way out? What's the best way to tackle this or deal with this?
So Dr. Sahu, in fact, very eloquently explained it. The only difficulty with his proposition, where you say hold accountable, the institutions accountable if they delay, it becomes very difficult in the scheme of things where you hold a quasi-judicial body or a tribunal responsible if they basically flout the timelines. That doesn't really work in India. I think the solution lies in 3 other places, in my view. First of all, we need to reinvent the NCLT. I've said that quite a few times. NCLT was created in 1999 on the recommendation of Justice Iradi Committee to solve the problems of 1990s, a closed economy, a Sick Industrial Companies Act, public sector enterprises, state-owned enterprises. We are today dealing with an economy which is booming, which is growing rapidly, a dynamic nation. You need 21st century institutions to deal with the laws of 21st century. We need NCLTs which has top-notch members who come from the industry expertise, not necessarily retired judges or retired bureaucrats. And I think in that, therefore, would require that the Madras High Court Bar Association judgment needs to be reviewed by the Honorable Supreme Court, because that is what suggested that this is what NCLT composition should be about. Secondly, I think as lawyers, we need to have a greater responsibility and a different approach when we argue economic laws cases in courts. We can't handle them using the toolkit of traditional dispute cases. And in a lot of cases, the lawyers need to reinvent themselves as to how they assist the court, don't delay, appreciate the timelines. And that will be a great help, because I have to admit that lawyers contribute to the delays quite significantly. And I know that I probably could invite higher of my fraternity in this, but this is something which needs to be said at some point in time. And the third, in my view, I do agree that we don't need 3 layers. We don't need to give a statutory appeal to the Honorable Supreme Court. We should only stick to providing a leave to appeal to Supreme Court in the event there is a question of law. But why have a statutory appeal? Because that you're yourself offering 3 layers of challenges, which is likely to take a year or so any which ways in delaying the closure. I think these are very significant revolutionary changes that are required, and I am hoping that this will happen in the next wave of reforms 2 years from now. It is inevitable, because it's very unlikely that 30 days giving reasons is going to change anything. It's a cultural thing, it's a mindset thing, it's a whole ecosystem there. And I'm sure what's going to happen, again, I'm going to invite trouble on this, is that the NCLT benches will shift the onus to the judge, to the lawyers. They'll say he has sought adjournment for 50 days to file rejoinder, and for delay, lawyer is sick. They'll record in the reasons for delay. The onus will shift to the lawyers, and lawyers. How does it matter? I earned my fee, so what? I'll ask 3-4 more adjournments, right? So that's not really going to happen beyond a point. But yes, costs may be imposed now on the parties because of the delays. But that's not the solution, is it? So in my view, it will make a difference, but not as significant. And I concur with Dr. Sahu on this. We need to change mindset. We need to change the entire approach, culture, ecosystem in which we operate.
Absolutely. Well, absolutely. I think those are some really important and valid points that you raised. And let's take the discussion forward now. Deepika Prasad, let me come back to you now. Let's try and understand really as far as the amendment bill is concerned. We'll look at IPs as well in specifically, and the amendment bill itself and IBC as a whole. What is really desired going into the future?
So I really feel that what is desired right now is an alignment of the IBC bill being with the entire statutory authorities and all the government bodies and all the stakeholders which are there in the entire IBC ecosystem to align with each other, whether it is the bankers, the PF departments or the income tax departments. I feel that unless all of these are aligned and the timelines which have been actually proposed in the amendment bill need to be followed, unless that part is achieved, and the NCLTs also are revamped to an extent that the timelines which have been proposed are followed, the amendment bill may not be able to see the results that it intends to see. So these are the things I believe that which need to be done so that the amendment bill really is able to be successful.
Absolutely. I think that's a very valid point, and that's important, really, so to speak, as far as the amendment bill is concerned. We need to see harmony as far as all the wings and all the arms are concerned to have a holistic IBC to going into the future. Ananda, let me come back to you now. Let's try and understand really, because of course the bill is now in the select committee. It's going to be opened up to consultations, to comments, to inputs as well. So what kind of inputs would you like to give really, and what kind of inputs should be incorporated within the amendment?
Basically, my input is to follow the law pure form and with pure intent from everybody, with every stakeholders. Because the law has been amended yet to address so many issues also. But yes, whatever they have issued the amendment bill and whatever they have addressed in this amendment bill, even if every stakeholders like judiciary as well as IPs, these creditors and other whole market and other statutory government authorities, if they will follow the law and in its instinct that it has to maximize the asset, it has to resolve those stresses and it will be come out as easy exit, not for the other things like how to get the credit, how much I am getting the money, how I will get entangled, how even the CD, if you wants to litigate the things, how to defer the things, that if that will not be there, this will be implemented very much good way, and it will fetch the result whatever the BLRC committee has dreamed out of these law. So my you can say, if my submission to this or suggestions to this, that we have to get whatever maximum out of these amendments we have to get, that to streamline the timelines, to do the CIIRP position in a good way, automation of these processes, the NCLT adjudicating authorities' responsibilities to be fixed in that way, or in some way do not litigate the things much more, just like a civil or criminal cases or civil courts or something. It should not be happen that BIFR and SICA provisions will continue here in NCLT. If this is a financial law, this should be treated as a financial law, and there must be some strict compliances as well as their fixation of responsibility and authorities also.
Absolutely. I think
Thank you.
minimize litigation is the key word that jumps out. At the end of the day, we need to ensure that litigation is minimized and made as less as possible.
Absolutely correct.
Okay, time to get closing comments now from all the panelists with the best way forward, what next, and what we would like to see going into the future. We are here in 2025, Dr. Sahu, maybe 3 years, 5 years down the line. What other kind of reforms do we need to prepare for? And is there anything that you would have done differently?
Let me tell you one big plus point of this bill is the responsibility on the key stakeholder, that is the committee of creditors and its members. They were so far outside the regulatory purview. Now they have been explicitly brought under the regulatory oversight. There will be regulations to regulate their conduct. But more important change is that henceforth their security interest will decide how much of a security they have. Till now, fictionally, they were saying that even if I am a secured creditor having security interest of 1%, but I will get the benefit of 100%. This will change the behavior of the committee of creditors or the banks at the time of lending. Because at the time of lending, every time they say that we take 100% security. If actually 100% security are available, we would not be having companies where the value left is 3%, 1%, and companies are getting into liquidation. So now this will ensure that the creditors behave properly. What I would have liked different is that this is an economic law. This law is meant for the people who are stressed, but if they're stressed, they must be treated quickly. And we know that in economic law like this, there are only two ways of resolution. One is by resolution plan, other is liquidation. But unfortunately, the narrative has been built up that resolution means resolution plan. If resolution by liquidation, it is not resolution. This misunderstanding is prevailing everywhere and it is disturbing the entire law, including in this legislation. It is told that we will start with creditor-led insolvency resolution process. If you do not get a plan, it will get converted to normal CIRP. If things do not work out, we will have a restoration, a rerun of the CIRP. Even then, at the end, there can also be a reinstatement of CIRP. So actually, we are pushing it even beyond the BIFR time. So you keep on adding these layers and layers, you will reach 2000 days very soon. What has not been addressed could have been addressed much better, not addressed at all, is the care for the operational creditors. I looked at the IBBI data for the quarter January, March. Financial creditors have got 75% of their claims. Operational creditors have got nearly 10% of their claims. So despite this kind of a wide disparity, we are ignoring a large segment, which is a very important stakeholder, but because they are operational creditor, they don't sit on the table, they don't get anything. So this treatment, ignoring again, I don't think it is fair. Another important aspect I wanted to talk is that in the sphere of legislation, there is a balance of power between the executive and the legislature. Worldwide, there is now a call that legislature has abdicated more of its responsibility to executive so that they are becoming gradually superfluous. Now that's why the call is that bring back the power from executive to legislature. How much of subordinate legislation you can allow to the executive agencies to make is one has to decide what is optimal level. I would have liked that this creditor-led process, pre-pack process, these are very process-oriented. Legislature should have given you on one line, the rest should have been left to rules. But when we are talking about a cross-border matter, when we are dealing with other countries, details should have been in the statute, not left to subordinate legislation. We had two-line provision 10 years ago in the IBC. We did not operationalize it. Now we have put another 2 lines. We will operationalize it. But given the importance of this issue, we have to deal with the various countries, stakes of various countries. Major provisions, basics, legislative things should have been in the statute.
Right. Absolutely. Absolutely. Suman Batra, closing comments from you. The best way forward. Where do we go from here? And also, if things had to be done differently, what do you think should have been omitted really as far as the amendment bill is concerned?
I have a difficulty with 2 provisions in particular. One, with regard to the withdrawal. Withdrawal has been made almost impossible. Withdrawal is something which I think facilitates closure of the enterprise, resolution, and to a large extent the objective of the code, which has been witnessed. Of course, there has been abuse of the process where people have used it to delay the process. Promoters have come at tail end of the process to throw in a plan. And therefore, some measures were needed. But what now has been said is that you cannot offer a withdrawal before the COC is constituted or after Form G has been issued, which means that expressions of interest have been invited from public against the plan. Now, that leaves a very small window available for a settlement by the copy debtor with these lenders. I think it's a little too harsh, and this needs to be expanded. The second difficulty I have is where they've said that if the resolution professional chooses not to file avoidance proceedings, because in his opinion, there's no case made out for avoidance, but the lenders choose to file it, fair enough. Lenders should be given the right. It exists in some form already, and they have been filing. There are precedents. But what it goes a step forward to say is that in such cases, then the NCLT should direct disciplinary proceedings against the IP. The law very clearly says that it is for the resolution professional to decide if, in his opinion, a case is made out. Now, this opinion is a very subjective thing. He may genuinely feel that there's no case made out, but the lenders may feel that there is an avoidance transaction made out. And just because lenders' voice is accepted, that doesn't mean that the resolution professional necessarily acted dishonestly. I think that's too harsh. But my problem is not just with this provision for penalty or disciplinary proceeding, but the fact that now what every IP will do is, irrespective whether there is a transaction avoidance made out or not, he will say, I'm going to file. I'm not going to take a chance that tomorrow the lenders say why he didn't file and I face disciplinary proceeding. So I will file, which means you have more applications in NCLT. You'll burden the NCLT with more avoidance, even in those cases where apparently there's no transaction, the avoidance is made up.
Right.
I think that needs a rethink. I'll just take 30 seconds to also,
please.
In terms of the futuristic, I think there are 4 things. What is missing? I think I was hoping that mediation would find a place. That's a national narrative at the moment. That's something which we all agree needs to be used more extensively, deeply. And we were hoping that this will find at least a foot in the door, kind of a provision. That is a bit of a disappointment. But there is still scope for that. There may be still representations to the select committee. But from a future point of view, although I do believe that it could have been attempted even now, but maybe for later. One, I think we need to reinvent the NCLT. I've made that point already.
Yes.
But for that, debate needs to be started. And I think we would have done this on your show today. The second, I think the individual insolvency. It's a very important thing. And I hope that Frank, at some point in time, you will actually invite me and Dr. Sau and some others to talk about this topic on a standalone basis, because for us, that's a very significant building piece of the building block for us wanting to become a developed country by 2047. And I'll be happy to share my view why. And therefore, we need to really do something about it very soon. And the third thing I think we'd like to see in future is to address the climate change issue. That's something knocking on our door already. It is impacting economies, it is impacting businesses, and it is going to have a very significant play in the economic affairs. And we could probably even set an example for the global fraternity by taking the first step into this. But it's complex, so maybe a year or two from now.
It is indeed complex, and it is something that needs to be addressed. And thank you for pointing out these very important, crucial aspects as well. I'd love to have you, Dr. Sahu, and the others as well to talk about all those three crucial aspects that you raised going into the future. And all of them need discourse and deliberation at the end of the day if we need to hit the nail on the head. All right. Deepika Prasad, final closing comments from you on the program with the best way forward.
So I believe that the best way forward, the first important thing is a very clear implementation of the amendment bill, which has actually been now proposed. I'm sure if the implementation happens in the right way and the right perspective, I'm sure the gaps that we are actually planning to plug will actually be done. It is all now about implementation. That is one. So second, I feel that we have been able to bring in the cross-border insolvency. But now the rules and regulations which will be made will decide whether the cross-border insolvency will be a success or not. Of course, the intent is very good, and the intent is clearly so that the different countries are brought into our framework and that we are able to follow the model law proposed by the UN Citral. But now the only thing is that how well the rules and regulations are framed and how well they are implemented with the clear intent that will decide whether we are able to really achieve what we wish to achieve with the amendment related to cross-border insolvency. Further, I would also like to say that, what I would have done differently is something that I believe that there should be a closure for all kinds of transactions and all kinds of litigations in a statutory manner. That is one which I feel that is still pending. That closure should be determined and should be clarified right now before we even move with the implementation of the bill for all the authorities other than the IP ecosystem. And next, I also wish what we could have done differently is that the other stakeholders, including the committee of creditors and the other, the operational creditors and the other stakeholders are also brought into the ambit with some kind of code or some kind of, expected rather deliverables from them, which would decide the fate of the amendment bill. Another thing which I feel which can be done a little differently is that the avoidance transactions which are there should be a special court which should be there for dealing with the avoidance transactions, which is still not there. And the intent of the avoidance transactions is still not being able to be realized. So that can only be done if we have some special benches for dealing with the avoidance transactions so that justice is actually done to them also. This is what I believe that we can really expect the legislature to work on. Thank you very much.
Absolutely. And Manindra, please close the show for us with your concluding remarks on the best way forward.
Best way forward is to the ruthless implementation of all laws and with all ecosystem stakeholders. First thing. Whatever they have done, whatever the modified, that has to be implemented in a ruthless way, that it will not end with the fate of SICA or BIFR. First thing. Second thing, what we can expect in this way, that they have not yet addressed the home buyers litigations and home buyers altogether their way forward. So home buyers and these real estate processes that has to be addressed. Another issue that has to be addressed is operational creditors, MSME organizations. Then third thing has to be addressed is the COC should be more responsible, and they must come in the ecosystem with accountability and their time driven system also, because they are creating a lot more time taking all those COC decisions. Third thing, what we expect, that these cross-border insolvency processes, we have to finalize the laws, regulations, and implementations and all those treaties with all those developed nations in a quick way and in a quick and time-bound processes, so that that will be implemented in a good way. Another issue is these group insolvency regulations should be much more clear for effective resolution of the companies. Last one is that we have to create an ecosystem that will create automation, lesser burden on the judiciary, more automation, more AI-driven systems, faster resolutions, and the implementation. So many things are there that we are waiting to the judiciary for approvals, but that will not take the time judiciary to get approval. And due to that, and that is only a systematic, you can say, process, a simple process. They have to acknowledge and note it in their records only. So these kind of things has to be withdrawn from the judiciary, direct them that things. Individuals, partnership firms, these processes should also be required to be in an equivalent way, and for the easy exit, and to show that our business is easy, so that through ease of business, the foreigners can trust on our system, because they want the easy exit. They want the conclusive, clear, and crisp method and process, so that they can exit easily. And the whole ecosystem, IBC was framed for that, but it has been derailed by these 9 years in between, somewhere in some points. So that has been plugged also. That will be implemented ruthlessly, I say again.
Okay. All right. On that
Thank
note,
you.
then, we'll have to call it a wrap on this edition of Discourse. I'd like to thank Dr. Sahu, Mr. Batra, Ms. Prasad, and Mr. Tiwari. Thank you so much for joining me on the program, sharing your views and putting things into perspective for us. It was a holistic discussion. Thank you for your time here on Bharata First. Well, that's it in this edition of the Discourse. Don't forget to like, subscribe, and hit the bell icon and share the content so that more people get to know about Bharata First. Until next time, this is Rausan Pereira signing off.